If there is no objection, the Journal of Proceedings of the trial are approved to date. I'm aware of one senator present who was unable to take the impeachment oath last Thursday. Will he please raise his right hand and be sworn? Do you solemnly swear that in all things appertaining to the trial of the impeachment of Donald John Trump, President of the United States, now pending, you will do impartial justice according to the Constitution and laws, so help you God?
I do.
The Secretary will note the name of the senator who has just taken the oath and will present the oath book to him for signature. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
I'd like to state that for the information of all senators, the trial briefs filed yesterday by the parties have been printed and are now at each senator's desk.
The following documents will be submitted to the Senate for printing in the Senate Journal: the precept issued January 16, 2020, the writ of summons issued on January 16, 2020, and the receipt of summons dated January 16, 2020. The following documents, which were received by the Secretary of the Senate, will be submitted to the Senate for printing in the Senate Journal pursuant to the order of January 16, 2020. The answer of Donald John Trump, President of the United States, to the articles of impeachment exhibited by the House of Representatives against him on January 16, 2020, received by the Secretary of the Senate on January 18, 2020. The trial brief filed by the House of Representatives received by the Secretary of the Senate on January 18, 2020. The trial brief filed by the President received by the Secretary of the Senate on January 20, 2020. The replication of the House of Representatives received by the Secretary of the Senate on January 20, 2020. And the rebuttal brief filed by the House of Representatives received by the Secretary of the Senate on January 21, 2020. Now, without objection, the foregoing documents will be printed in the congressional record. I note the presence in the House of the Senate, in the Senate chamber, of the managers on the part of the House of Representatives and counsel for the President of the United States.
Mr. Chief Justice.
The Majority Leader is recognized.
I send to the desk a list of floor privileges for closed sessions. It's been agreed to by both sides. I ask that it be inserted in the record and agreed to by unanimous consent.
Without objection.
For the further information of all senators, I'm about to send a resolution to the desk providing for an outline of the next steps in these proceedings. It will be debatable by parties for 2 hours, equally divided. Senator Schumer will then send an amendment to the resolution to the desk. Once that amendment has been offered and reported, we'll have a brief recess. When we reconvene, Senator Schumer's amendment will be debatable by the parties for 2 hours. Upon the use or yielding back of time, I intend to move to table Senator Schumer's amendment. And so, Mr. Chief Justice, I send a resolution to the desk and ask that it be read.
The clerk will read the resolution.
Senate Resolution 483, to provide for related procedures concerning the articles of impeachment against Donald John Trump, President of the United States. Resolved, that the House of Representatives shall file its record with the Secretary of the Senate, which will consist of those publicly available materials that have been submitted to or produced by the House Judiciary Committee, including transcripts of public hearings or markups and any materials printed by the House of Representatives or the House Judiciary Committee pursuant to House Resolution 660. Materials in this record will be admitted into evidence subject to any hearsay, evidentiary, or other objections that the President may make after opening presentations are concluded. All materials filed pursuant to this paragraph shall be printed and made available to all parties. The President and the House of Representatives shall have until 9 a.m. on Wednesday, January 22nd, 2020, to file any motions permitted under the rules of impeachment, with the exception of motions to subpoena witnesses or documents or any other evidentiary motions. Responses to any such motions shall be filed no later than 11 a.m. on Wednesday, January 22nd, 2020. All materials filed pursuant to this paragraph shall be filed with the Secretary and be printed and made available to all parties. Arguments on such motions shall begin at 1 p.m. on Wednesday, January 22nd, 2020, and each side may determine the number of persons to make its presentation, following which the Senate shall deliberate, if so ordered, under the impeachment rules, and vote on any such motions. Following the disposition of such motions, or if no motions are made, then the House of Representatives shall make its presentation in support of the articles of impeachment for a period of time not to exceed 24 hours over up to 3 session days. Following the House of Representatives' presentation, the President shall make his presentation for a period not to exceed 24 hours over up to 3 session days. Each side may determine the number of persons to make its presentation. Upon the conclusion of the President's presentation, senators may question the parties for a period of time not to exceed 16 hours. Upon the conclusion of questioning by the Senate, there shall be 4 hours of argument by the parties, equally divided, followed by deliberation by the Senate, if so ordered under the impeachment rules, on the question of whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. The Senate, without any intervening action, motion, or amendment, shall then decide by the yeas and nays whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. Following the disposition of that question, other motions provided under the impeachment rules shall be in order. If the Senate agrees to allow either the House of Representatives or the President to subpoena witnesses, the witnesses shall first be deposed, and the Senate shall decide after deposition which witnesses shall testify pursuant to the impeachment rules. No testimony shall be admissible in the Senate unless the parties have had an opportunity to depose such witnesses. At the conclusion of deliberations by the Senate shall vote on each article of impeachment.
The resolution is arguable by the parties for 2 hours equally divided. Mr. Manager Schiff, are you a proponent or opponent of this motion?
Managers are in opposition to this resolution.
Thank you. Mr. Cipollone, are you a proponent or opponent of the motion?
Mr. Chief Justice, we are a proponent of the motion.
Then, Mr. Cipollone, your side may proceed first, and we'll be able to reserve rebuttal time if you wish.
Thank you, Mr. Chief Justice. Majority Leader McConnell, Democratic Leader Schumer, Senators. My name is Pat Cipollone. I am here as counsel to the President of the United States. Our team is proud to be here representing President Trump. We support this resolution. It is a fair way to proceed with this trial. It is modeled on the Clinton resolution, which had 100 senators supporting it the last time this body considered an impeachment. It requires the House managers to stand up and make their opening statement and make their case. They have delayed bringing this impeachment to this House for 33 days to this body. And it's time to start with this trial. It's a fair process. They will have the opportunity to stand up and make their opening statement. They will get 24 hours to do that. Then the President's attorneys will have a chance to respond. After that, all of you will have 16 hours to ask whatever questions you have of either side. Once that's finished and you have all of that information, we will proceed to the question of witnesses and some of the more difficult questions that will come before this body. We are in favor of this. We believe that once you hear those initial presentations, the only conclusion will be that the President has done absolutely nothing wrong, and that these articles of impeachment do not begin to approach the standard required by the Constitution, and in fact, they themselves will establish nothing beyond those articles. You look at those articles alone and you will determine that there is absolutely no case. So we respectfully ask you to adopt this resolution so that we can begin with this process. It is long past time to start this proceeding, and we are here today to do it. And we hope that the House managers will agree with us and begin this proceeding today. We reserve the remainder of our time for rebuttal.
Mr. Chief Justice, Senators, and Counsel for the President, the House managers, on behalf of the House of Representatives, rise in opposition to Leader McConnell's resolution. Let me begin by summarizing why. Last week, we came before you to present the articles of impeachment against the President of the United States for only the third time in our history. Those articles charge President Donald John Trump with abuse of power and obstruction of Congress. The misconduct set out in those articles is the most serious ever charged against a president. The first article, abuse of power, charges the president with soliciting a foreign power to help him cheat in the next election. Moreover, it alleges, and we will prove, that he sought to coerce Ukraine into helping him cheat by withholding official acts, two official acts: a meeting that the new president of Ukraine desperately sought with President Trump at the White House to show the world, and the Russians in particular, that the Ukrainian president had a good relationship with his most important patron, the President of the United States. And even more perniciously, President Trump illegally withheld almost $400 million in taxpayer-funded military assistance to Ukraine, a nation at war with our Russian adversary, to compel Ukraine to help him cheat in the election. Astonishingly, the President's trial brief filed yesterday contends that even if this conduct is proved, that there is nothing that the House or this Senate may do about it. It is the President's apparent belief that under Article 2 he can do anything he wants, no matter how corrupt, outfitted in gaudy legal clothing. And yet, when the founders wrote the impeachment clause, they had precisely this type of misconduct in mind. Conduct that abuses the power of his office for personal benefit, that undermines our national security, that invites foreign interference in our democratic process of an election. It is the trifecta of constitutional misconduct justifying impeachment. In Article 2, the President is charged with other misconduct that would likewise have alarmed the founders: the full, complete, and absolute obstruction of a co-equal branch of government, the Congress, during the course of its impeachment investigation into the President's own misconduct. This is every bit as destructive of our constitutional order as the misconduct charged in the first article. If a president can obstruct his own investigation, if he can effectively nullify a power the Constitution gives solely to Congress, indeed the ultimate power the Constitution gives to prevent presidential misconduct, then the president places himself beyond accountability, above the law, cannot be indicted, cannot be impeached. It makes him a monarch, the very evil against which our Constitution and the balance of powers it carefully laid out was designed to guard against. Shortly, the trial on these charges will begin, and when it has concluded, you'll be asked to make several determinations. Did the House prove that the President abused his power by seeking to coerce a foreign nation to help him cheat in the next election? And did he obstruct the Congress in its investigation into his own misconduct by ordering his agencies and officers to cooperate, refuse to cooperate in any way, to refuse to testify, to refuse to answer subpoenas for documents, and through every other means? And if the House has proved its case, and we believe the evidence will not be seriously contested, you will have to answer at least one other critical question. Does the commission of these high crimes and misdemeanors require the conviction and removal of the President? We believe that it does, and that the Constitution requires that it be so, or the power of impeachment must be deemed a relic or a casualty to partisan times, and the American people left unprotected against a president who would abuse his power for the very purpose of corrupting the only other method of accountability, our elections themselves. And so you will vote to find the president guilty or not guilty, to find his conduct impeachable or not impeachable. But I would submit to you, these are not the most important decisions you will make. How can that be? How can any decision you will make be more important than guilt or innocence, than removing the president or not removing the president? I believe the most important decision in this case is the one you will make today. The most important question is the question you must answer today. Will the president and the American people get a fair trial? Will there be a fair trial? I submit that this is an even more important question than how you vote on guilt or innocence, because whether we have a fair trial will determine whether you have a basis to render a fair and impartial verdict. It is foundational, the structure upon which every other decision you will make must rest. If you only get to see part of the evidence, if you only allow one side or the other a chance to present their full case, your verdict will be predetermined by the bias in the proceeding. If the defendant is not allowed to introduce evidence of his innocence, it's not a fair trial. So too for the prosecution. If the House cannot call witnesses or introduce documents and evidence, it's not a fair trial. It's not really a trial at all. Americans all over the country are watching us right now. And imagine they're on grand jury or they're on jury duty. Imagine that the judge walks into that courtroom and says that she's been talking to the defendant. And at the defendant's request, the judge has agreed not to let the prosecution call any witnesses or introduce any documents. The judge and the defendant have agreed that the prosecutor may only read to the jury the dry transcripts of the grand jury proceedings. That's it. Has anyone on jury duty in this country ever heard a judge describe such a proceeding and call it a fair trial? Of course not. That's not a fair trial. It's a mockery of a trial. Under the Constitution, this proceeding, the one we are in right now, is the trial. This is not the appeal from a trial. You are not appellate court judges. Okay, one of you is. And unless this trial is going to be different from every other impeachment trial or any other kind of trial for that matter, you must allow the prosecution and defense, the House manager and the President's lawyers, to call relevant witnesses. You must subpoena documents that the President has blocked, but which bear on his guilt or innocence. You must impartially do justice as your oath requires. So what does a fair trial look like in the context of impeachment? The short answer is it looks like every other trial. First, the resolution should allow the House managers to obtain documents that have been withheld. First, not last, because the documents will inform the decision about which witnesses are most important to call. And when the witnesses are called, the documentary evidence will be available and must be available to question them with. Any other order makes no sense. Next, the resolution should allow the House managers to call their witnesses. And then the President should be allowed to do the same and any rebuttal witnesses. And when the evidentiary portion of the trial ends, the parties argue the case. You deliberate and render a verdict. If there's a dispute as to whether a particular witness is relevant or material to the charges brought, under the Senate rules, the Chief Justice would rule on the issue of materiality. Why should this trial be different than any other trial? The short answer is it shouldn't. But Leader McConnell's resolution would turn the trial process on its head. His resolution requires the House to prove its case without witnesses, without documents, and only after it's done will such questions be entertained, with no guarantee that any witnesses or any documents will be allowed even then. That process makes no sense. So what is the harm of waiting until the end of the trial, of kicking the can down the road on the question of documents and witnesses? Besides the fact it's completely backwards, trial first, then evidence, besides the fact that the documents would inform the decision on which witnesses and help in their questioning, the harm is this: you will not have any of the evidence the President continues to conceal throughout most or all of the trial. And although the evidence against the President is already overwhelming, you may never know the full scope of the President's misconduct or those around him. And neither will the American people. The charges here involve the sacrifice of our national security at home and abroad, and a threat to the integrity of the next election. If there are additional remedial steps that need to be taken after the President's conviction, the American people must know about it. But if, as a public already jaded by experience has come to suspect, this resolution is merely the first step of an effort orchestrated by the White House to rush the trial, hide the evidence, and render a fast verdict, or worse, a fast dismissal, to make the President go away as quickly as possible to cover up his misdeeds, then the American people will be deprived of a fair trial and may never learn just how deep the corruption of this administration goes, or what other risks to our security and elections remain hidden. The harm will also endure for this body. If the Senate allows the President to get away with such extensive obstruction, it will affect the Senate's power of subpoena and oversight just as much as the House. The Senate's ability to conduct oversight will be beholden to the desires of this President and future presidents, whether he or she decides they want to cooperate with a Senate investigation or another impeachment inquiry and trial. Our system of checks and balances will be broken. Presidents will become accountable to no one. Now, it has been reported that Leader McConnell has already got the votes to pass this resolution, the text of which we did not see until last night and which has been changed even moments ago. And they say that Leader McConnell is a very good vote counter. Nonetheless, I hope that he's wrong. And not just because I think this process, the process contemplated by this resolution, is backwards and designed with the result in mind, and that the result is not a fair trial. I hope that he's wrong because whatever senators may have said or pledged or committed has been superseded by an event of constitutional dimension. You have all now sworn an oath. Not to each other, not to your legislative leadership, not to the managers or even to the Chief Justice. You have sworn an oath to do impartial justice. That oath binds you. That oath supersedes all else. Many of you in the Senate and many of us in the House have made statements about the President's conduct, or this trial, or this motion, or expectations. None of that matters now. That is all in the past. Nothing matters now but the oath to do impartial justice. And that oath requires a fair trial, fair to the President and fair to the American people. But is that really possible? Or as the founders feared, has factionalism or an excessive partisanship made that now impossible? One way to find out what a fair trial should look like, devoid of partisan consideration, is to ask yourselves, how would you structure the trial if you didn't know what your party was? And you didn't know what the party of the president was? Would it make sense to you to have the trial first and then decide on witnesses and evidence later? Would that be fair to both sides? I have to think that your answer would be no. Let me be blunt. Let me be very blunt. Right now, a great many, perhaps even most Americans, do not believe there will be a fair trial. They don't believe that the Senate will be impartial. They believe that the result is pre-cooked. The president will be acquitted. Not because he is innocent, he is not, but because the senators will vote by party and he has the votes. The votes to prevent the evidence from coming out, the votes to make sure the public never sees it. The American people want a fair trial. They want to believe their system of government is still capable of rising to the occasion. They want to believe that we can rise above party and do what's best for the country, but a great many Americans don't believe that will happen. Let's prove them wrong. Let's prove them wrong. How? By convicting the president? No, not by conviction alone. By convicting him if the House proves its case, and only if the House proves its case, but by letting the House prove its case, by letting the House call witnesses, by letting the House obtain documents, by letting the House decide how to present its own case, and not deciding it for us. In sum, by agreeing to a fair trial. Now let's turn to the precise terms of the resolution, the history of impeachment trials, and what fairness and impartiality require. Although we have many concerns about the resolution, I will begin with its single biggest flaw. The resolution does not ensure that subpoenas will, in fact, be issued for additional evidence that the Senate and the American people should have, and that the President continues to block to fairly decide the President's guilt or innocence. Moreover, it guarantees that subpoenas will not be issued now, when they would be most valuable to the Senate, the parties, and the American people. According to the resolution the leader has introduced, first, the Senate receives briefs and filings from the parties. Next, it hears lengthy presentations from the House and the President. Now, my colleagues, the President's lawyers, have described this as opening statements. But let's not kid ourselves. That is the trial that they contemplate. The opening statements are the trial. They'll either be most of the trial or they'll be all the trial. If the Senate votes to deprive itself of witnesses and documents, the opening statements will be the end of the trial. So to say, let's just have the opening statements and then we'll see, means let's have the trial. And maybe we can just sweep this all under the rug. So you'll hear these lengthy presentations from the House. There will be a question and answer period for the senators, and then and only then, after essentially the trial is over, after the briefs have been filed, after the arguments have been made, after the senators exhaust all their questions, only then will the Senate consider whether to subpoena crucial documents and witness testimony that the President has desperately tried to conceal from this Congress and the American people. Documents and witness testimony that, unlike the Clinton trial, have not yet been seen or heard. It is true that the record compiled by the House is overwhelming. It is true the record already compels the conviction of the President. In the face of unprecedented resistance by the President, the House assembled a powerful case, evidence of the President's high crimes and misdemeanors that includes direct evidence and testimony of officials who were unwilling and unwitting in this scheme and saw it for what it was. Yet there is still more evidence, relative and probative evidence, that the President continues to block, that would flesh out the full extent of the President's misconduct and those around him. We have seen that over the past few weeks, new evidence has continued to come to light. as the Nonpartisan Government Accountability Office has determined that the hold on military to Ukraine was illegal and broke the law, as John Bolton has offered to testify in the trial, as one of the President's agents, Lev Parnas, has produced documentary evidence that clarifies Mr. Giuliani's activities on behalf of the President and corroborates Ambassador Sondland's testimony that everyone was in the loop. As documents released under the Freedom of Information Act have documented the alarm at the Department of Defense while the President illegally withheld military support for Ukraine, an ally at war with Russia, without explanation. As a senior Office of Management and Budget official, Michael Duffy instructed Defense Department officials on July 25th, 90 minutes after President Trump spoke by phone with President Zelensky, the Defense Department should pause all obligation of Ukraine military assistance under its purview. 90 minutes after that call. Duffy added, quote, "Given the sensitive nature of the request, I appreciate your keeping that information closely held to those who need to know to execute the direction." Although the evidence is already more than sufficient to convict, there is simply no rational basis for the Senate to deprive itself of all relevant information in making such a hugely consequential judgment. Moreover, as the President's answer to his summons and his trial brief make clear, the President now attempts to contest the facts, albeit in false and misleading ways. But the President should not have it both ways. He should not be permitted to claim that the facts uncovered by the House are wrong, while also concealing mountains of evidence that bear precisely on those facts. If this body seeks impartial justice, it should ensure that subpoenas are issued and that they are issued now, before the Senate begins extended proceedings based on a record that every person in this room and every American watching at home knows does not include documents and witness testimony. It should, because the President would not allow it to be so. Complying with these subpoenas would not impose a burden. The subpoenas cover narrowly tailored and targeted documents and witnesses that the President has concealed. The Senate deserves to see the documents from the White House, the State Department, the Office of Management and Budget, the Department of Defense. These agencies already should have collected and at least preserved these documents in response to House subpoenas. Indeed, in some cases, agencies have already produced documents in FOIA lawsuits, albeit in heavily redacted form. And witnesses with direct knowledge or involvement should be heard. That includes the President's acting Chief of Staff, Mick Mulvaney, his former National Security Advisor, John Bolton, who has publicly offered to testify, two senior officials integral to implementing the President's freeze on Ukraine's military aid also have very relevant testimony. Why not hear it? Robert Blair, who serves as Mulvaney's senior advisor, Michael Duffy, a senior official at OMB, and other witnesses with direct knowledge that we reserve the right to call later, but these witnesses with whom we wish to begin the trial. Last month, President Trump made clear that he supported having senior officials testify before the Senate during his trial, declaring that he would love to have Secretary Pompeo, Mr. Mulvaney, now former Secretary Perry, and, quote, many other people testify in the Senate trial.
So, when it's fair, if it would be fair in the Senate, I would love to have Mike Pompeo, I'd love to have Mitch, I'd love to have Rick Perry, and many other people testify.
The Senate has an opportunity to take the President up on his offer to make his senior aides available, including Mr. Mulvaney and Secretaries Perry and Pompeo. But now the President is changing his tune. The bluster of wanting these witnesses to testify is over, notwithstanding the fact that he has never asserted a claim of privilege during the course of the House impeachment proceedings. He threatens to invoke one now in a last-ditch effort to keep the rest of the truth from coming out. The President sends his lawyers here to breathlessly claim that these witnesses or others cannot possibly testify because it involves national security. Never mind that it was the President's actions in withholding military aid from an ally at war that threatened our national security in the first place. Never mind that the most impeachable, serious offenses will always involve national security because they will involve other nations, and that misconduct based on foreign entanglement was what the framers feared most. The president's absurdist argument amounts to this: we must endanger national security to protect national security. We must make a president's conduct threatening our security beyond the reach of impeachment power if we are to save the presidency. This is dangerous nonsense. As justices of the Supreme Court have underscored, the Constitution is not a suicide pact. But let us turn from the abstract to the very concrete, and let me show you just one example of what the president is hiding in the name of national security. There is a document which the president has refused to turn over, in which his top diplomat in Ukraine says to two other appointees of the president, "As I said on the phone, I think it's crazy to withhold security assistance for help with a political campaign." The administration refuses to turn over that document and so many more. We only know about its existence. We have only seen its contents because it was turned over by a cooperating witness. This is what the president would hide from you and from the American people. In the name of national security, he would hide graphic evidence of his dangerous misconduct. The only question is, and it is the question raised by this resolution, will you let him? Last year, President Trump said that Article 2 of the Constitution will allow him to do anything he wanted. And evidently believing that Article 2 empowered him to denigrate and defy a co-equal branch of government, he also declared that he will fight all subpoenas. Let's hear the president's own words.
Then I have an Article 2 where I have the right to do whatever I want as president.
Well, we're fighting all the subpoenas.
True to his pledge to obstruct Congress, when President Trump faced an impeachment inquiry in the House of Representatives, he ordered the executive branch to defy every single request on every single subpoena. He issued this order through his White House counsel, Pat Cipollone, on October 8, the same counsel that stood before you a moment ago to defend the president's misconduct. He then affirmed it again at a rally on October 10. Following President Trump's categorical order, we never received key documents and communications. It is important to note, in refusing to respond to Congress, the president did not make any formal claim of privilege ever. Instead, Mr. Cipollone's letter stated, in effect, that the president would withhold all evidence in the executive branch unless the House surrendered to demands that would effectively place President Trump in charge of the inquiry into his own misconduct. Needless to say, that was a non-starter and designed to be so. The president was determined to obstruct Congress no matter what we did. And his conduct since, his attacks on the impeachment inquiry, his attacks on witnesses, have affirmed that the president never had any intention to cooperate under any circumstance. And why? Because the evidence and testimony he conceals would only further prove his guilt. The innocent do not act this way. Simply stated, this trial should not reward the president's obstruction by allowing him to control what evidence is seen and when it is seen and what evidence will remain hidden. The documents the president seeks to conceal include White House records, including records about the president's unlawful hold on military aid, State Department records, including text messages and WhatsApp messages exchanged by the State Department and Ukrainian officials, and notes to file written by career professionals as they saw the president's scheme unfold in real time. OMB records demonstrating efforts to fabricate an after-the-fact rationale for the president's orders and showing internal objections that the president's orders violated the law. Defense Department records reflecting bafflement and alarm that the president suspended military aid to a key security partner without explanation. Many of the president's aides have also followed his orders and refused to testify. These include central figures in the impeachment inquiry, including White House Chief of Staff Mick Mulvaney, former National Security Advisor John Bolton, and many others with relevant testimony like Robert Blair and Michael Duffy. Mr. Blair, who serves as a senior advisor to Acting Chief of Staff Mulvaney, worked directly with Mr. Duffy, a political appointee in the Office of Management and Budget, to carry out the President's order to freeze vital military and security assistance to Ukraine. The Trump administration has refused to disclose their communications, even though we know from written testimony, public reporting, and even Freedom of Information Act lawsuits that they were instrumental in implementing the hold and extending it at the President's express direction, even as career officials warned accurately that doing so would violate the law. The President has also made the insupportable claim that the House should have enforced its subpoenas in court and allowed the President to delay his impeachment for years. If we had done so, we would have abdicated our constitutional duty to act on the overwhelming facts before us and the evidence the President was seeking to cheat in the next election. We could not engage in a deliberately protracted court process while the President continued to threaten the sanctity of our elections. Resorting to the courts is also inconsistent with a Constitution that gives the House the sole power of impeachment. If the House were compelled to exhaust all legal remedies before impeaching the President, it would interpose the courts or the decision of a single judge between the House and the power to impeach. Moreover, it would invite the President to prevent his own impeachment by endlessly litigating the matter in court, appealing every judgment, engaging in every frivolous motion or device. Indeed, in the case of Don McGahn, the President's lawyer who was ordered to fire the special counsel and lie about it, he was subpoenaed by the House in April last year, and there is still no final judgment. A president may not defeat impeachment or accountability by engaging in endless litigation. Instead, it's been the long practice of the House to compile core evidence necessary to reach a reasoned decision about whether to impeach, and then to bring the case here to the Senate for a full trial. That is exactly what we did here, with an understanding that the Senate has its own power to compel documents and testimony. It would be one thing if the House had shown no interest in documents or witnesses during its investigation, although even there, the House has the sole right to determine its proceedings, as long as it makes the full case to the House, as it did. But it is quite another when the President is the cause of his own complaint, when the President withholds witnesses and documents and then attempts to rely on his own noncompliance to justify further concealment. President Trump made it crystal clear we would never see a single document or a single witness when he declared, as we just watched, that he would fight all subpoenas. As a matter of history and precedent, it would be wrong to assert that the Senate is unable to obtain and review new evidence during a Senate trial, regardless of why evidence was not produced in the House. You can and should insist on receiving all of the evidence so you can render impartial justice and can earn the confidence of the public in the Senate's willingness to hold a fair trial. Under the Constitution, the Senate does not just vote on impeachments. It does not just debate them. Instead, it is commanded by the Constitution to try all cases of impeachment. If the founders intended for the House to try the matter and the Senate to consider an appeal based on the cold record from the other chamber, they would have said so. But they did not. Instead, they gave us the power to charge and you the power to try all impeachments. The framers chose their language and the structure for a reason. As Alexander Hamilton said, the Senate is given awful discretion in matters of impeachment. The Constitution thus speaks to senators in their judicial character as a court for the trial of impeachments. It requires them to aim at real demonstrations of innocence or guilt, and it requires them to do so by holding a trial. The Senate has repeatedly subpoenaed and received new documents, often many of them while adjudicating cases of impeachment. Moreover, the Senate has heard witness testimony in every one of the 15 Senate trials, full Senate trials in the history of this republic. including those for Presidents Andrew Johnson and Bill Clinton. Indeed, in President Andrew Johnson's Senate impeachment trial, the House managers were permitted to begin presenting documentary evidence to the Senate on the very first day of the trial. The House managers' initial presentation of documents in President Johnson's case carried on for the first 2 days of trial, immediately after which witnesses were called to appear in the Senate. This has been the standard practice in prior impeachment trials. Indeed, in most trials, this body has heard from many witnesses, ranging from 3 in President Clinton's case to 40 in President Johnson's, and well over 60 in other impeachments. As these numbers make clear, the Senate has always heard from key witnesses when trying an impeachment. The notion that only evidence that was taken before the House should be considered is squarely and unequivocally contrary to Senate precedent. Nothing in law or history supports it. To start, consider Leader McConnell's own description of his work in a prior Senate impeachment proceeding. After serving on the Senate Trial Committee in the case of Judge Claiborne, Leader McConnell described how the Senate committee, quote, labored intensively for more than 2 months, amassing the necessary evidence and testimony. In the same essay, Leader McConnell recognized the full body's responsibility for amassing and digesting evidence. There was certainly a lot of evidence for the Senate to amass and digest in that proceeding, which involved charges against a district court judge. The Senate heard testimony from 19 witnesses, and it allowed for over 2,000 pages of documents to be entered into the record over the course of that trial. At no point did the Senate limit evidence to what was before the House. It did the opposite, consistent with unbroken Senate practice in every single impeachment trial, every single one. For example, of the 40 witnesses who testified during President Johnson's Senate trial, only 3 provided testimony to the House during its impeachment inquiry. Only 3. The remaining 37 witnesses in that presidential impeachment trial testified before the Senate. Similarly, the Senate's full first impeachment trial, which involved charges against Judge Pickering, involved testimony from 11 witnesses, all of whom were new to the impeachment proceedings and had not testified before the House. There are many other examples of this point, including the Senate's most recent impeachment trial of Judge Porteous in 2010. It is one that many of you and some of us know well. It, too, is consistent with this long-standing practice. There, the Senate heard testimony from 26 witnesses, 17 of whom had not testified before the House during its impeachment inquiry. Thus, there is a definitive tradition of the Senate hearing from new witnesses when trying articles of impeachment. There has never been a rule limiting witnesses to those who appeared in the House or limiting evidence before the Senate to that which the House itself considered. And that is because, as Senator Hiram Johnson explained in 1934, the integrity of Senate impeachment trials depend heavily upon the witnesses who are called, their appearance on the stand, their mode of giving testimony. There is thus an unbroken history of witness testimony in Senate impeachment trials. Presidential and judicial. I would argue in the case of a president, it is even more important to hear the witnesses and see the documents. Any conceivable doubt on this score, and there should be none left, is dispelled by the Senate's own rules for trial of impeachment. Obtaining documents and hearing live witness testimony is so fundamental that the rules of procedure and practice in the Senate when sitting on impeachment trials, which date back to the 19th century, devote more attention to the gathering, handling, and admission of new evidence than any other single subject. These rules expressly contemplate that the Senate will hear evidence and conduct a thorough trial when sitting as a court of impeachment. At every turn, they reject the notion that the Senate would take the House's evidentiary record, blind itself to everything else, and vote to convict or acquit. For example, Rule 6 says the Senate shall have the power to compel the attendance of witnesses and enforce obedience to its orders. Rule 7 authorizes the presiding officer to rule on all questions of evidence, including but not limited to questions of relevancy, materiality, and redundancy. This rule, too, presumes that the Senate trial will have testimony, giving rise to such questions. Rule 11 authorizes the full Senate to designate a committee of senators to receive evidence and take testimony at such times and places as the committee may determine. As Rule 11 makes clear, the committee's report must be transmitted to the full Senate for final adjudication. But nothing herein, the rule states, shall prevent the Senate from sending for any witness and hearing his testimony in open Senate or by order of the Senate involving the entire trial in the open Senate. Here, too, the Senate's operative impeachment rules expressly contemplate and provide for subpoenaing witnesses and hearing their testimony as part of the Senate trial. And the list goes on. These rules plainly contemplate a robust role for the Senate in gathering and considering evidence. They reflect centuries of practice of accepting and requiring new evidence in Senate trials. This Senate should honor that practice today by rejecting this resolution. What about the Clinton trial? What about the Clinton trial, it will be argued? Even if we are departing from every other impeachment trial in history, including the impeachment of President Andrew Johnson, what about the Clinton trial? Aren't we following the same processes in the Clinton trial? The answer is no. First, the process for the Clinton trial was worked out by mutual consent among the parties. That is not true here, where the process is sought to be imposed by one party on the other. Second, all of the documents in the Clinton trial were turned over prior to the trial. All 90,000 pages of them, so they could be used in the House's case. None of the documents have been turned over by the President in this case. And under Leader McConnell's proposal, none may ever be. They certainly won't be available to you or to us during most or all of the trial. If we are really going to follow the Clinton precedent, the Senate must insist on the documents now, before the trial begins. Third, the issue in the Clinton trial was not one of calling witnesses, but of recalling witnesses. All of the key witnesses in the Clinton trial had testified before the grand jury or been interviewed by the FBI, one of them dozens of times, and their testimony was already known. President Clinton himself testified on camera and under oath before the Senate trial. He allowed multiple chiefs of staff and other key officials to testify, again, before the Senate trial took place. Here, none of the witnesses we seek to call, none of them have testified or been interviewed by the House. And as I said, the President cannot complain that we did not call these witnesses before the House when their unavailability was caused by the President himself. And last, as you will remember, those of you that were here, the testimony in the Clinton trial involved decorum issues that are not present here. You may rest assured, whatever else the case may be, such issues will not be present here. In sum, the Clinton precedent, if you're serious about it, if we're really serious about modeling this proceeding after the Clinton trial, the Clinton precedent is one where all the documents had been provided up front, where all the witnesses had testified up front prior to the trial. That is not being replicated by the McConnell resolution, not in any way, not in any shape, not in any form, far from it. The traditional model followed in President Johnson's case and all of the others is really the one that's most appropriate to the circumstances. The Senate should address all the documentary issues and most of the witnesses now, not later. The need to subpoena documents and testimony now has only increased due to the President's obstruction for several reasons. First, his obstruction has made him uniquely and personally responsible for the absences of the witnesses before the House. Having ordered them not to appear, he may not be heard to complain now that they followed his orders and refused to testify. To do otherwise only rewards the President's obstruction and encourages further future presidents to defy lawful process in impeachment investigations. Second, if the president wishes to contest the facts and his answer and trial brief indicates that he will try, he must not continue to deny the Senate access to the relevant witnesses and documents that shed light on the very factual matters he wishes to challenge. The Senate trial is not analogous to an appeal where the parties must argue the facts on the basis of the record below. There is no record below. There is no below. This is the trial. Third, the president must not be allowed to mislead the Senate by selectively introducing documents while withholding the vast body of documents that may contradict them. This is very important. The president must not be allowed to mislead you by introducing documents selectively and withholding all of the rest. All of the relevant documents should be produced so there is full disclosure of the truth. Otherwise, there is a clear risk that the president will continue to hide all evidence harmful to his position while selectively producing documents without any context or opportunity to examine their creators. And finally, you may infer the president's guilt from his continuing efforts to obstruct production of documents and witnesses. The president has said he wants witnesses like Mulvaney and Pompeo and others to testify, and that his interactions with Ukraine have been perfect. Counsel has affirmed today that will be the president's defense. His conduct was perfect. It's perfect. Perfectly fine to coerce an ally by withholding military aid to get help cheating in the next election. That will be part of the president's defense, although albeit not worded in that way. But now he has changed course and does not want these witnesses to testify. The logical inference in any court of law would be that the party's continued obstruction of lawful subpoenas may be construed as evidence of guilt. Let me conclude. The facts will come out in the end. The documents which the president is hiding will be released through the Freedom of Information Act or through other means over time. Witnesses will tell their stories in books and film. The truth will come out. The question is, will it come out in time? And what answer shall we give if we did not pursue the truth now and let it remain hidden until it was too late to consider on the profound issue of the president's guilt or innocence? There are many overlapping reasons for voting against this resolution, but they all converge on a single idea: fairness. The trial should be fair to the House, which has been wrongly deprived of evidence by a president who wishes to conceal it. It should be fair to the president, who will not benefit from an acquittal or dismissal if the trial is not viewed as fair, if it is not viewed as impartial. And fair to you senators, who are tasked with the grave responsibility of determining whether to convict or acquit, and should do so with the benefit of all of the facts. And fair to the American people, who deserve the full truth and who deserve representatives who will seek it on their behalf. And with that, Mr. Chief Justice, I yield back.
Mr. Cipollone, Mr. Sekulow, you have 57 minutes available.
Thank you, Mr. Chief Justice, members of the Senate, Leader McConnell, Democratic Leader Schumer. It's also my privilege to represent the President of the United States before this chamber. Senator Schumer said earlier today that the eyes of the founders are on these proceedings. Indeed, that's true. But it is the heart of the Constitution that governs these proceedings. And what we just heard from Manager Schiff, courts have no role, privileges don't apply. What happened in the past, we should just ignore. In fact, Manager Schiff just said, try to summarize my colleague's defense of the president. He said, not in those words, of course, which is not the first time Mr. Schiff, has put words into transcripts that did not exist. Mr. Schiff also talked about a trifecta. I'll give you a trifecta. During the proceedings that took place before the Judiciary Committee, the President was denied the right to cross-examine witnesses. The President was denied the right to access evidence. And the President was denied the right to have counsel present at hearings. That's a trifecta that violates the Constitution of the United States. Mr. Schiff did say the courts really don't have a role in this. Executive privilege, why would that matter? It matters because it's based in the Constitution of the United States. One manager said that it is you that are on trial, the Senate. He also said that, and others did, that you're not capable of abiding by your oath. And then we had the invocation of the ghost of the Mueller report. I know something about that report. It came up empty on the issue of collusion with Russia. There was no obstruction. In fact, the Mueller report, to the contrary of what these managers say today, came to the exact opposite conclusions of what they say. Let me quote from the House impeachment report at page 16. Although President Trump has in times invoked the notion of due process, an impeachment trial, an impeachment inquiry is not a criminal trial and should not be confused with.
Condensing this to just 2 days instead of 3 or 4 like it was in the Clinton case. So that really stands out to me, that Mitch
required by the Constitution, and in fact, they themselves
by the Senate's own rules for trial of impeachment.
I want you to picture what it's going to be like in this country the first day
that will govern the trial And we could see why this resolution was kept from us and from the American people. This is nothing like the process that was used in the Clinton trial. To begin with, and this is, I think, most indicative, in the Clinton trial, both Senate leadership worked out a bipartisan proposal for how the trial would be conducted. That obviously has not happened here. Senator McConnell did not consult at all with Senator Schumer on the contents of this text. I would imagine that Senator Schumer only got to see it probably around the same time that we did in the House. And the reason this was kept hidden is that it does not prescribe a process for a fair trial. And the American people desperately want to believe that the Senate will give both the President and the House of Representatives a fair trial. This resembles nothing like the Clinton proceeding. For the first point, in the Clinton case, if we're truly following the Clinton precedent, all of the documents were provided before the trial, more than 90,000 of them. Does this resolution provide for the President to provide the documents before the trial? No, it does not. It leaves that question of whether the House will ever see these documents, whether the American people will ever see these documents, to the end and only the end, with no guarantee that this material will ever be shown to the House or to the American people. That is a profound departure from the Clinton trial. Without the documents, you can't make important judgments about even which witnesses should be called or what questions should be asked of the witnesses when you do. So that is a profound departure from the Clinton precedent. On the subject of witnesses, it is also a deep departure from Clinton, where all of the witnesses testified before the Senate trial. The issue in the Clinton trial was not whether they would testify. They had testified already. They had been interviewed already, some dozens of times. The question in the Clinton trial was, will they be recalled? Will they be required to testify again? And that question was answered in the affirmative. Here, though, if we're following the Clinton precedent, all of these witnesses should testify, should be deposed before the trial begins, not after the trial is over. So this is not at all the model used in the Clinton case as well. This resolution even goes so far in another departure from the Clinton precedent to say they're not even going to admit the evidence that was received in the House, that they're going to even postpone the decision about whether any of the witness testimony will actually be part of the record. And finally, they are compressing the time of the trial. Whereas the Clinton trial, managers had 6 hours a day to present over a course of days, they're now presenting that we double the amount of time each day so that the proceedings can conceivably go well into the night when apparently Senator McConnell hopes the American people will not be watching. This is not a process for a fair trial. This is the process for a rigged trial. This is the process if you do not want the American people to see the evidence. This is a process you use if you want to, hand in hand, working in concert with the President, allow the President to continue to obstruct the Congress and deny the truth to the American people. Thankfully, however, we know the truth. The evidence is already overwhelming, and that evidence is that the President abused the power of his office, withheld hundreds of millions of dollars of needed military aid to an ally at war in order to coerce that ally into interfering in our election. And then when he was caught, obstructed the Congress to cover it up. That truth is inescapable, no matter how McConnell wishes to structure this trial. But we will be appealing to the manager, we will be appealing as managers to the senators today to live up to the oath they have just taken, to do impartial justice, and to hold a fair trial. And we're happy to respond to questions.
Mr. Chairman, do you think you need something?
People ask me what culinary school I went to. My answer is India. I learned that you don't add masala just to the food.